¿Qué tal? Buenas tardes. Mi nombre es Guilliana Paredes. Quiero darles la bienvenida a nombre de Estrategia Regulatoria a todos los asistentes y a los panelistas que han mostrado interés en nuestro primer evento, el cual lanzamos de la mano del ex-ed, nuestro partner en la educación digital. En esta oportunidad tengo el placer de contar con la profesora Charla Alexander. Ella es la fundadora y líder del laboratorio de Legal Analytics en la Georgia State University. Además, tiene bastante experiencia en el ámbito de la investigación y ha publicado varios papers sobre la materia. Without no more words, Charlotte, the floor is yours.
Okay, muchas gracias y buenas tardes a todos. I'm going to switch to English porque mi español es como más o menos, but I am so happy to be here to present a little bit about legal analytics. And so let me make sure I'm good here. One moment. Okay. All right, so everybody can see the screen. Okay, wonderful. So I'm going to be talking about 3 different projects that I have been involved with in the area of legal analytics. And by legal analytics, what I mean is projects that use the tools of data science to study legal questions, often using the text of legal documents, but also sometimes using other types of data as well, so numerical data in addition to text data. So I will be presenting 3 examples of legal analytics projects. The first involves litigation and using court docket sheets, which in the United States at least are the chronological record of everything that happens in a court case. So that's the first example, which will be a court-focused litigation example. The second example project that I will talk about is also a court and litigation-focused project where I worked with some colleagues to try to predict how a judge would rule based on aspects of the briefs that the lawyers filed in court. And then the third example that I'll discuss is a transactional law example, not coming out of litigation and courts, but rather coming out of contracts, where we developed a tool to assess how similar contracts were to one another. And so I'll walk through each of the 3 of these in relatively quickly, because I really want to make sure that we have time to talk among all of the panelists and to hear from the audience about your thoughts and applications to the work that you do. So the first case study, or the first project I'll talk about, as I mentioned, we used docket sheets. And so in the United States, the federal courts have a single digital case records platform that is called PACER. And so we were able to go into PACER and retrieve in bulk 2 years worth of docket sheets for every case that was filed in federal court around the whole country. And so on the left of the screen, you can see an example of a docket sheet. And so at the top here, we see the name of the case, the judge, the amount that was in issue, when it was filed, when it ended, and then we see information on the plaintiff, and it's cut off here, but you would see the defendants listed below, also the lawyers. And then below, we have a table that's in HTML format that lists everything that has happened, every event that happened in the case, and then these links are hyperlinks to PDFs of the documents that the parties filed in the case, and then also the written decisions that the judge issued. And so our goal with this project was to build code that would sit on top of these docket sheets, or that could take these docket sheets in as the input and convert this text, which is relatively unstructured. So convert and standardize this text into a structured data set. So we could draw some conclusions about the patterns and trends that we see in the cases that make their way through federal court. And we're building a public-facing website that will extract this information from docket sheets and turn it into things like what we see here, which is the average case duration, or the amount of time it took for this one particular court. This is the court around Chicago, Illinois. This one particular court, the amount of time it took to resolve a case from beginning to end. So that's just an example of the type of work we're doing. Now, I'll dig in a bit further and give you some more detail about how we're doing this, because the process to go from millions of pages of docket sheets to this sort of chart is actually quite complicated and involves developing some machine learning algorithms to execute this task. So if you think about litigation, I think of this as thinking about Borges, El Jardín de Senderos que bifurcan, if I'm getting that right. But if you're thinking about the garden of forking paths, right? So litigation can start in one place, and then it can go through any number of events, and then it ends. And so if you're thinking about a civil case, and here I'm using the US court system as an example, but a complaint could be filed in a civil case, and then it could just go straight to settlement. The parties might resolve the case with no intervention by a judge. Another pathway that a case might go down is the defendant might file a motion to dismiss. Maybe the judge denies it, and then maybe the parties settle. But you can imagine cases going down a variety of different paths, hitting these different moments in litigation, and then ending in a variety of different ways. And so what we are attempting to do, again, to go back to the example of the docket sheet, is to take this text and turn the text into a set of moments in litigation, so then we can describe a case according to the pathway it took and then the end point where it ended. And so I should say we've started this and we've gotten much farther in civil cases than we have in criminal, but we're working on a similar process for criminal cases. And so, as I mentioned, there's quite a bit that goes into this process methodologically. And so, as an example, what we are seeing here are excerpts from docket sheets from different courts around the country, all of which are settlement. So all of these docket sheets, when I read this text as an expert, as a lawyer, I can understand that each of these different docket entries is an indication or a signal that the parties have settled. But as you can see, the words that are used are all quite different, and they don't always say the word settlement. So what we've developed is a machine learning algorithm that we have trained based on a set of sample settlement entries to quote unquote learn what a settlement looks like, even when different words are used and even when the word settlement does not appear. And so we've taken all of this variation in the language and turned it into a single dot, which is settlement. And so that's the idea, is to do this process over and over and over again and expose our algorithm to enough variations in the language so that the algorithm can accurately classify what happens in each case and what the results, what the end point is. And so as an example, for a single case, we would feed in the docket sheet and come up with this particular pathway of how it ended. The bonus that we get is you'll see the dates here. We can calculate how long it takes each case to get from one point to another, and we can calculate how much activity happens in a case based on the number of docket entries on the docket sheet. And then if we move from a single case to thinking about many cases, thinking about the system of courts as a whole, we might be able to compare judges. So maybe Judge A, if we're looking at a particular case type, maybe we see that that judge tends to dismiss or grant motions to dismiss many, many times more frequently than other judges. And so once we start to bring in judges, lawyer characteristics, case type characteristics, we can start moving toward thinking about differences across different aspects of the judicial system. So we might compare Judge A to Judge B, and then, as I said, we might start to bring in other characteristics of the cases so we can start to get a sense of how the court systems work as a whole. So that's the summary. If you'd like to learn more about that particular project, it's actually part of a very large research group where we have about 20 to 25 different researchers and 8 to 10 universities involved. And so you can visit the website for that research group there if you'd like to learn more about that work. So that's the first case study. The second case study, we're still in the area of courts and litigation. But here, instead of focusing on docket sheets, which is, again, that chronological record of what happens in a case. Instead, we're focusing on the briefs that the lawyers file in court, and then also the decisions that judges make. And this is a research project that is coming out in a law review article that I have on here in a few slides. But the goal here was to assemble a set of briefs, or they're sometimes called a memorandum, that lawyers file arguing their side of the case. So assemble the set of briefs from one side, from the plaintiff side and the defendant side, and then also find the judge's opinion where the judge has made a decision about who wins. And so we have these groupings of the two opposing briefs and then the judge's opinion. And what we were interested in studying is whether we could extract characteristics of the briefs and use those characteristics to predict how the judge would rule. And so our theory was, well, why do we care about the briefs? Why do we care about what the lawyers file in court? Well, because we think lawyers are doing a variety of different things when they're writing their brief to add value, to advocate for their client. So writing style might predict whether a brief is successful or not, the types of arguments being made, the way the lawyer uses the facts of the case, and the law, the precedent or the case law that the lawyers cite. So we were interested in exploring all of these different aspects of legal writing and trying to connect it, to connect those different brief characteristics to the success of that lawyer. So as I said, we assembled a set of briefs that were filed in court. We had them in PDF format, so we had them in an electronic format. And we used a whole set of tools to try to capture the different aspects of the lawyer's writing. So, for example, we identified words that were positive or negative intensifiers. So by that I mean saying extraordinarily or very, or these emphasis intensifying adverbs. We identified times where words were repeated, like again, also. So lawyers were re-emphasizing the arguments they were making. Also emotion words. And we did all this in an automated way using natural language processing tools from computer science that could take the words in the briefs and identify these different aspects of the writing. We also just counted how long the briefs were, how long were the sentences, how complex was the language, and then also what case law and statutes and regulations did the lawyers cite. which cases did they cite, and then how many cases did they cite. And all of this, we added to our analysis control variables to capture which court the briefs were filed in, what type of case, and what type of case was being litigated. So with all of this, we ran a variety of different models to try to understand whether any of these would predict the success of that brief or whether that side in the case would win. And what we found that was the most predictive was that last set of variables, citations. And here we were looking at citations to previous decisions, right? So citations to precedent, to previous case law. And what we're looking at here is a network graph. And so what we were able to do is we looked at every brief and we said, for example, this is a citation to a US Supreme Court case as an example. So if a brief cited this case, how likely was it that other briefs that cited that same case won their case? So in other words, we were building a network or sort of a neighborhood or a cluster of briefs that were winners, that were winning briefs. And we found the citations that those winning briefs had in common. And so we were able to use this network diagram just to illustrate that if a brief cited this particular case, this was a winning cluster of cases. Whereas some of these other ones, like this particular case citation, we only had 2 winning briefs associated with that one. So using this methodology, we were able to kind of identify the winners, which clustered together, and the losers, or the cases that were less likely to win. We saw here, this is just in simple terms, what's going on here is that on the x-axis, this is the number of other briefs that shared the same citations. And then this here was the probability that that brief or that lawyer would win. And so no case, so if there was a brief that shared no citations with any other brief, none of those cases won. So in other words, if your brief is out here all alone and is not connected to any other brief, it has a very low probability of winning. And the more cases that your citations shared in common, or excuse me, the more citations that your brief shared in common with other winning briefs, the more likely you were to win. So this article that describes this project and these results is coming out in the Texas Law Review. And so it's up online already, even though it's not published. But if you want to read more about that project, that's there. And it describes in much more detail the methodologies we used. Okay, so I'll shift to the last project, which shifts from the courts and litigation over to a transactional law setting. And so our interest here was to assess contract similarity. And so the reason we were interested in this project is we were working with a company that is a really big multinational company. And the company is always entering into contracts with vendors, employment contracts, real estate contracts, all different kinds of contracts. And in every part of their business, they had a template or a model contract that contained the terms that the business was willing to agree to. But the executives of this business were worried that the employees, when they actually were executing contracts, that those employees were changing the terms of the contract. And so the executives were worried that they didn't have a system for tracking the actual contracts that their company was entering into, because they knew that the actual contracts were not the same as the model or the template contract. And so what we did is develop a similarity tool that would allow us to go to assess the similarities and differences between the actual contracts and the template. And so what we did, this was also a project where we used text analysis, where we wrote code, computer code, that could computationally and automatically compare the contracts to one another. And so one method we used was called bag of words. And all that bag of words does is it just compares the exact words in the template contract to the exact words in the actual contract. And you can see we actually just started by doing a state-by-state analysis. And we had our model contract, and this shows how similar these contracts were in each state to the model contract. And you can see that they were actually all fairly similar. Even the least similar set of contracts from New York still shared 60% of the words of the model contract. And as an example, I just compared it to the Wikipedia entry about Harry Potter to just show that that was quite different. But all the rest of these, when you just look at whether they share the same words, they were still fairly similar to one another. So this very simple example maybe was useful. Maybe you could see that, gosh, New York is fairly different from Arkansas, but it doesn't tell you very much about how the contracts were different from one another. So we use some additional, more sophisticated methodologies to get more meaning out of this contract comparison than just a simple comparison of words. And here I'll just spend a really short minute about talking about this particular methodology, but I'm happy to talk more because this is my area of interest and I teach this also in our law school. So we next used a methodology called word embeddings, which basically allows us to find synonyms for words. Because when you just compare what words exist in two contracts, you might not get at the fact that one contract might be using synonyms or very similar language, and it is in fact a very similar contract, even though the words are different. And so this methodology takes models, language models, that have been exposed to millions and millions of words from Google News or from Wikipedia. And these models can learn from this text that they are exposed to, and that allows the computer model to identify the fact that the word cat, for example, is very similar to the word feline. It's not similar to the word human. It's not very similar to the word royalty. Also, cat is not a verb, and it's not plural. So these models that you can use can learn about the structure of language so that you can go beyond just comparing the presence or absence of words and start to get at other words that may mean the same thing and really start to get at the meaning of language rather than just the presence or absence of words. And so with these models, we're able to identify the specific way that text is different. And the reason I have this up here is so as an example, humans and chimpanzees share 98% of our DNA, but the 2% that's different is really, really important. And in the same way, you might have two contracts that share 98% of the words, but the 2% that's different might make a real difference in the legal significance of the contract. And so what we wanted to get at is, what is that 2%? What's different when two contracts are different from one another? And so using those word embedding methodologies, we could start getting at what is the common text, and then what is the unique text. And so here just is an example from some different contracts that were coming from different states in this company's business. And we could start to see how the words match up, and then see also that Colorado had a whole lot of additional text and a whole lot of additional difference beyond some of the common language that the two contracts shared. And then we could start to identify the words that were most differentiating. So we could compare on the state level versus the model. So the different contracts, so some contracts had very specific language around, and I should say these were all insurance related that we're looking at right here. So they might have very specific language around different aspects of those contracts, whereas these words up here were very specific and very unique to the model contract or the template contract we were working with. So you can start to dig into where those differences are, not only measuring the fact that they were different. So that's the end. I am happy to answer questions about any of that. I know that was a lot of information all at once, and I really look forward to hearing from my fellow panelists and from the audience. So I will stop there.
Thank you very much, Charlotte, for your data and your knowledge. This is like golden for us. We are living in a data-driven world, even more each day. We are making a step forward, but legal sector should not be behind, you know, and that is what is happening, at least in my consideration, in Latin America. Many sectors are going forward with these challenges of data-driven decisions, but legal sector is still traditional, and with all it costs, I mean, and the life cost for lawyers to spend many hours doing the same work over and over again. No, there is many people who thinks that lawyers, we just read the law and write word sheets, and we are doing more than that. And this is the living proof that lawyers, we can be science too. We can do science. We have in the panelists. In the panel, we have Diego Álvarez. He's an Ecuadorian lawyer from Niubox. We have Alejandra Huachaca. She's a member of Lawgic Tec, a Peruvian association, in order to find this point of connection between technology and lawyering. And we also have two data scientists to make the conversation more interesting. We have Víctor. He works in a bank, and Yuri, he also works in a bank. Bank is one of the sectors that, at least in Latin America, is more data driven right now. You know, they are taking a lot of insights and a lot of value from the data or from the consumers and their business. But lawyers, are we doing this? So my first question, or maybe the first invitation to share her thoughts is for Alejandra. Alejandra, how do you see Latin America in this big challenge of getting value from the data that is hidden in the court, in the laws, in the contracts? How do you see we can take this challenge or this step into the academic, or maybe add value to our business?
Hi everyone, thanks for the invitation. My name is Alejandra Huachaca, and as Juliana said, I'm a co-founder of Lawgic Tec, which is a non-profit organization committed with the research and promotion of issues related to law and new digital technologies. So we are very pleased to participate in this event. And answering your question, actually I have some questions that I think later I can propose to Charlotte, but answering your question, Juliana, here in Peru, we have a lack of digitalization. So we are in a digital transformation process, but we are starting this process. So here in Peru, I think the main problem is that we don't have all the data digitalized. So we have a lot of data, a lot of papers, a lot of cases in physical. And Another problem I see here in Peru is that we are not an homogeneous country. So every city is different and works different from another. So in order to start this case of study, the first one, with all these sheets with the summary of all the cases, I would like to have that in Peru. I think that will be very efficient, but it's very difficult because we have all the, well, not all, but a very big part of the cases in court cases, in physical, and I think that is the main issue we have to solve first in Peru in order to start this kind of projects.
Great, Alejandra. Charlotte mentioned that you guys in America have PISR, right? And maybe that is the first step that we need to take. We need to become all this data from the paper to a digital form. And that is the first step we need to take as a country. That should come from a public policy goal, maybe, in order to achieve this value. Do you mention that you have some question, Alejandra? Did you mention?
Yes, one of my questions was very related to your question. Well, I find it extremely important what Charla mentioned, how law can complement with new technologies and how this can play a decisive role in digital transformation. In that sense, I have one question, that is, how can we implement these tools? And I'm focusing on study case 1, this legal analytics tool in Peru, considering that we have a judiciary system that is so unpredictable, and that most of the data is in physical.
Okay.
So, do you want me to answer, or?
Oh, yeah.
Yes, if you can, please.
I was going to say that we have two variables, that we have much paper, and unpredictable rules, unpredictable judges. Please.
Yes, so I should say that the PACER system that I mentioned and the docket sheet that I showed you, that comes from our federal court system. So we have, and I apologize, you probably already know this, but we have a federal court system, and then we also have state court systems. And so in each of the 50 states, there's a separate system, and sometimes more than one separate system. Sometimes it's at the level of the county. And the federal system, we have the advantage of having that single electronic system. But the states are much more similar to what you described, which is some states like California are very advanced in terms of digitization and the availability of electronic records. Other states like Georgia, where I live, many of our records are still in paper hard copy form. So the reason we could do that project was because we focused on the federal system, but our state system, which is much bigger, is way far behind the federal system. So I just want to say that, because it's not like we have everything solved here. We do not. Okay, so paper, yes. And so I think that, so I don't know whether this would be plausible or feasible, but one thing you might do is find a single court that has paper records. But if those paper records are themselves fairly consistent, you might scan them in to, create a PDF from those and then extract the data from the electronic version. And I could imagine doing maybe a pilot study to show that if you had electronic records, what you could do with them. And then maybe that could be something you could use from a policy perspective to show that an electronic court record system could be used in so many different ways to understand what's happening in court, to find inefficiencies, to sort of improve the operation of courts. But the digitization process in the United States took maybe a decade to accomplish. And so the PACER system that I mentioned did not happen overnight. It took a long time and a lot of money to implement. So that's one thought about the paper piece. The unpredictability, I think, it's interesting because a data science, so maybe Victor and Yuri would say, if you have enough data, nothing is unpredictable, right? So if you have enough data, you might be able to find some predictive power in your data. And so I don't know about whether judges are truly unpredictable or they only seem unpredictable because they have never been studied. I don't know.
Very interesting what you're saying, Charlotte. Actually, there is a lot of knowledge hidden behind these sentences, and judges are human beings. Maybe they have their own bias, and we just have the goal to find this bias and to understand better the judges. It's my path to ask Victor, from your experience in the bank, in this solid market that is already data driven, how do you see legal market getting into applying your science, your models, to get value to society?
Hello, I am Victor, here from Peru, working at the banking field. Well, I think it's very interesting how you achieve to merge that two files, right? The law and the data science. It's very interesting because I was thinking that it's interesting to think that the balance of the justice can be tilted in favor of the perhaps of the party that can dominate these analysis techniques, making it possible to increase the chances of winning for a litigant who perhaps may not be right. Okay, do you think that access to this knowledge can make it more difficult to obtain justice for a certain part of the population?
So I think that's a very important question, and one that I have thought about a lot, because on the one hand, you could imagine that the data that we extract from the court records, like Guilliana was saying, that's hidden in there and we bring it out, if we make that public and we make predictive tools available to everybody, then even litigants with lower resources should be able to benefit from knowing what the chances are that they will win, or they might be able to shape their strategy about, if I do this before this judge, I'm most likely to win. But the reality, of course, is that these sorts of projects cost money. And the big law firms in the United States are investing in data science because they are hiring data scientists and they are doing these kinds of projects, but because they have the money to fund those projects. And so I think that the data and the insight from the data in and of itself could benefit everybody, all litigants. But the danger is that because it's expensive to extract the data and find the insight. The danger is that those insights and those benefits only go to the wealthy, powerful people and companies.
Mhm.
And
Mhm.
so what I've been working on is various efforts to build tools that are open source, that are publicly available, and to work with government to try to create public tools that are available for everybody. But I think it's a real danger. And I'm glad you asked the question, because it's something that I think those of us who are working to develop these tools, we need to make sure that we're not just reinforcing the power structures that exist and helping the winners keep winning and helping and keeping the losers out.
Mhm.
What a great insight. Make a better access to justice. Use data for good of the welfare. That is my step to give the word to Diego. Diego, how do you see this? How do you see these models in order to make a better system, a better system in order to achieve justice in a more simple way or a more cheaper way, democratize justice and access to it?
Excellent. Thank you very much, Juliana. I'm very pleased to be part of this panel. Thank you very much for the invitation. My name is Diego Álvarez. I am a lawyer. I focus my practice on technology and data protection. I wanted to share with the system some ideas. The first idea I wanted to share is that in our countries, we come from a law system different than the North American one. So we put a lot of effort on the development on regulation above the ruling system. So I think one of the biggest opportunities we have to develop legal analytic projects are the ones that are focused on how our regulation is created, how instead of our rulings, because our ruling systems is a mess, like it's a complete mess. But probably our first step for us will be interesting to understand how our regulation system works, what kind of insights we can get from how laws and how regulation is created in our countries, because sometimes also one of the biggest problems for justice is that we don't have equal regulations on different topics. And the law itself is not just in so many cases. In some cases, a single legal code can give benefits to a sector of the society above another one. So probably in the case of our countries, understanding with analytics our regulations can be an interesting first step. Another question that I have for Charlotte is, what are the main challenges of incorporating these kind of tools? What are those dark spots that we are not seeing as we start in developing these new trends?
So I think that's really fascinating about regulations, and clearly I'm coming from a different system. And I think there was a question in the Q&A from Lourdes that was similar about sort of how these tools might apply in a different system. And I'm not an expert, but I do think anytime you have a grouping of documents or a set of text, right, and then you can perform all different analyses, right? You could compare regulations in one that affect one part of society to another. You can, so if you think about, if you could imagine what you could learn if you devoted all of your time to reading regulations and then turn that over to a computer, right, to extract those insights, So I guess I'll say that I imagine that there are many possible applications. Without knowing more about how it would work, I probably can't say much, but I would be happy to brainstorm with anybody on this call about how you might take some of these text analysis tools and methods and approach regulations instead. Main challenges, just quickly. So as many of us on this call know, anytime you're working with machine learning, these sort of algorithmic approaches and automated computational approaches to modeling, there's always a danger that your model is only learning from the data you give it. So if I'm trying to study some aspect of what happens in the law, but I only expose my model to a subset of cases, it will only learn from what's in that subset of cases. And my model will not be very good at predicting what happens outside that subset of cases. And so bias, that's a form of bias, or having limited training data, is always a problem and a challenge with any of these kinds of tools. And I will say, back to Alejandra's point about digitalization or not, that can be a challenge. So if, like I said, in our country, our states are very different in how much of their court records they have digitized. And so I might build a beautiful model that works perfectly in California, but it's not useful at all in Georgia because we don't have our court records digitized. And so it's a very basic problem with having the data as the input on the front end of the model and having a wide enough set of data to expose your model to.
How important is to have a variety of data so you can have a good model and good results. In order to follow the conversation about regulation, it's true, in Peru we have a problem that we have so many rules that it's impossible for a normal citizen to know all the rules that they have to comply. So we are in this race to create a culture of better regulation with all these economic methodologies. But how easy this can be if we just have this approach, not just by economics, but also data science, technology, And this is my question for Yuri. Yuri and I are always talking about how to make legal system or legal sector more data driven, and he's always skeptical about lawyers doing this. Maybe Yuri, you can share your concerns about Peru and or culture about data, how difficult is for us to achieve a first step into the culture of data-driven decisions.
Thank you, Juliana. Thank you, Charlotte. Well, I don't know if it's difficult to improve legal sector with data. I think the difficult thing is that how that non-digital data convert to digital data. I think this is the main problem to start analyze the legal sector and the yachts and case by case how it will be affect a future if that legal market, also the justice as a social problem. I think in order the work of Charlotte, I think in the first case, in identifying the case, the progress of the case, I am thinking as data scientist. I think it's better to predict the duration or a survival mode with survival models. How long is the duration of a case? If you find some variables affect the duration, maybe you can improve, or as a governance, as an institution, affect this variable to reduce and maybe affect better and or affect positively to reduce the time to the time of duration of the case. I think if the duration is lower, is less, maybe we are talking about justice better than if the duration is long. And the other thing that I think is have high risks is when we want to predict if a brief will be successful or not. Maybe one variable could be the case that have more vertex in your graph model, and it could be one case could be affecting more cases than the others. I think this is the bias, the real bias. If this case is good, maybe could affect positively, but if the case would be negative for more of the society that is in the court, maybe it's a real bias that will be regulated. And I have a question. If you have considered to use these duration models in your future papers that you expose, Charlotte?
Yes, so using a survival model or a hazard model is something we've started to play around with. So when I was showing you that docket sheets project, I should say we have not yet finished that work. And so we don't currently have all of those litigation moments identified, but we are close. We think for civil cases in the next three or 4 months, we'll have that work finished. And then we'll have the data, the structured data that we can use to feed into a survival model like you suggested, Yuri, which I think is brilliant, that makes total sense. And that's something we've been thinking about, to be able to see which cases are more and less likely to have a longer duration. And then what are the factors that are predictive of duration, right? So can we predict duration successfully based on the other features of the cases that we know about? So yes, that's a future step.
I would love to predict the compliance of a rule. That will be very useful for us because we have too many rules that are not compliant. I have a very interesting question from Juliana. She's asking about the pandemic, how the pandemic has impacted the digitalization in our countries. I think this is applying for any country that has been going through the pandemic. Maybe United States, you talk about that we have the same situation in some states that not all is digital in digital mode. Do you think pandemic has make improvement about it?
I think the pandemic has shown that it is possible to do more of the work of the courts digitally. And so I have not seen a dramatic change, but I think what the pandemic has done is kind of opened the eyes of the courts and the court administrators to the possibility of shifting in that direction.
Maybe, Diego, do you think in Ecuador that pandemic has helped legal sector to face these challenges about the digitalization and maybe do our job in a new way or in a better, efficient way?
Yes, since we start experience the pandemic, a lot of initiatives start to evolve regarding digitalization for the legal sector in Ecuador. The first and the most simple one was that we started to use video tools in order to make the hearings. But actually our local authority who regulates courts started to establish some obligations for judges and courts itself to be more efficient in the way they are providing the rulings, and starting using our local digital system for reviewing processes. So we absolutely got a better use of those tools. We are probably in the process. We still have some very funny and very weird situations where in some small cities of the country, the judges still send notifications in order for the parts to be in presence in the courtroom for certain aspects. But I think it's a process that we are living. From the private sector, we are also experiencing some good new practices. A lot of big law firms are starting to using some softwares in order to make it more efficient their work. We are, for the first time in our history, start to hearing that some big companies or big law firms in our country using automatization softwares for contracts, or contract lifecycle management softwares, or those kind of tools that 3 years ago were like a myth for us. So probably we are doing these baby steps in order for starting to using the technology in our favor.
Great. I have a question from Rodolfo. He says, by using massive information and use of legal data analytics, the confidentiality of information and protection of personal data can be put at risk? Oh, that is a great question for lawyers in the panel. What do you think about data privacy rules applying to these models? Maybe Diego, Alejandra, Charla.
I'd be happy to start very briefly to talk about, so I think there are two questions here. So one is personal data, like in the United States, our social security number is our sort of national identification number. And anytime that appears in a court document, the court is supposed to redact it. But in our working with court records, we find that there are errors, right? And so social security numbers come through. And so in the first project I talked about, we have been building our own tools to parse our documents and find identifying information like social security numbers and scrub them out. But the other question, which I think is maybe not as specific as things like social security numbers, but for example, if someone has a criminal case and they're being prosecuted, and that is public, right? The courts are a public institution, but is it ethical to then make that the fact that they had a criminal case so much more easily available and so much more widely known by making that data part of a larger public-facing project, right? So I think there's some technical questions about redaction, but I think there are also ethical questions about taking information that is maybe from one of the worst times in someone's life when they have been part of a court case and making that more publicly available through a tool that gives better access to court records, whether that's ethical. And so I think that there's some real questions there. And so someone's name then may need to be redacted. That's my thinking about it. I'd love to hear others as well.
I believe that there is a very good opportunity for anonymization techniques because, well, not all the data is from criminal cases, but that is the more sensitive one. Well, we have just been 1 hour talking about this interesting theme. I want to give thanks to Charla very much for sharing your time, sharing your knowledge with us, all the panelists. Thanks to Niubox, thanks to Lawgic Tec, thanks to the BCP and Scotiabank for giving time to their employees to share ideas with us. And I'm gonna let 1 minute to Melissa, our partner in this talk from LexEd, to say goodbye to our guests. And I hope we have the opportunity to see all again and to share another insights of work, and maybe if there is the opportunity to apply legal analytics here in Peru and Ecuador and extract all the knowledge we can in order to make a better society.
Gracias, Juliana. Bueno, en nombre de Estrategia Regulatoria y LexEd, quiero agradecer a Charlotte, Alejandra, Diego, Víctor, Yuri y a ti, Juliana, por habernos acompañado y compartido tan interesante información con nuestros asistentes. Y asimismo agradecer a quienes se conectaron y se quedaron hasta el final de este encuentro y por haberse animado a escuchar un tema nuevo y que, como muchos de nuestros panelistas dijeron, recién está en desarrollo aquí en nuestro país. En ese sentido, aprovecho para comentarles que el LexEd es un centro de capacitación para la innovación y transformación del sector legal, cuyo principal motor es tanto el enriquecimiento de la actividad jurídica como el impulso de su fortalecimiento y profesionalización en la región. Justamente mediante la organización de este tipo de espacios que sirven de plataforma no solo para promover temáticas prácticas y de actualidad para los interesados, sino también para apoyar y dar visibilidad a aquellos especialistas con amplia y reconocida trayectoria comprometidos con la actividad académica. Es por eso que los invitamos a seguirnos en todas nuestras redes sociales y visitar nuestra página, que es www.leded.com, para no perderse ninguna de las invitaciones a nuestros eventos. Y nada, nos estamos viendo. Muchas gracias.